Juliana, shall we?
Yes, of course. So, hello everyone. Thank you for being here. I'm Juliana. I'm here with Rafael. And today we're going to talk a little bit about the industrial designs in Brazil. So, this presentation that we prepared, it's a guide to navigating Brazil's design protection. And we had some recent updates. So, we are going to talk about the practice, the pitfalls, and these manual updates for you. So why it's important to look to industrial designs even more now. So we had, as I mentioned, we had this update manual. Actually, it started being reviewed last year in August, and now this month, last month actually, it ended and published all the updated manual. So this brings significant procedural clarifications now. Although we have those changes on the manual, the substantive law remains unchanged while the administrative practice has been refined and clarified. And now we're going to talk not only about those changes, but the entire procedure of industrial design protection in Brazil. Now we have a little bit more of discipline from the examiners. So you have less discretion for them and more procedural rigor and predictability for practitioners, which brings us more security while talking about the industrial design protection. And some automatic consequences. So the priority and the united issues now trigger immediate procedural effects without the the examiner discretion. So now some actions may have automatic consequences without involving the examiner's office action or something like that. What is industrial design? Let's begin with that. Here in Brazil, it protects the ornamental and aesthetic aspects of a product. So it's more about the visual appearance created through some specific design choices. So you have 2 or 3D forms applied to an object. This is configures the ornamental part of a product. And what really matters is the visual elements, so lines, shapes, colors, and patterns that distinguish this product from others. And also the focus is in the appearance. So the visual impression is what really matters, and the technical function does not qualify to be considered an industrial design. So here we have an example of in the photos of what it's really important for the Brazilian law to see the visual application of industrial design. What is possible in Brazil is the confidentiality requirement. So it guarantees that the application will only be made available for technical analysis 180 days after the date of filing, safeguarding the filing date. So you keep the same filing date, but it will only be disclosed 180 days after that. It is possible, it's not mandatory, but it is possible in Brazil. You can request it at the time of the filing. It will take 180 days, as I mentioned, and you can also withdraw the application within this time. But you need to require this withdrawal within 90 days. So half of the time you have 90 days to withdraw it without being disclosed. So you keep the restriction of this industrial design. But it's a possibility here in Brazil. What is not protected by industrial design here in the country? Purely artistic work. So fine art, sculptures, and some creative works without the industrial application, they are outside of this design protection. They cannot be considered one. Common geometric shapes, so basic shapes forming like products lacking of this distinctive character, or they are all excluded from this protection. Function drive forms, also, as I mentioned, what really matters is not just the function, but also the visual effects. So the shapes that are essentially by technical function or mechanical necessity, they are not registered as industrial designs here. Some architecture products, Building designs and architectural projects, they are usually not qualified, but we have some very limited exceptions to that. So it's better to have a consultation before filing that so we can analyze if it can be possible or not. Things that are contrary to moral and good customs. So what is obscene or glorification of crimes, what defames or violates the honor or image of individuals and groups, violates the freedom of conscience, belief, religious worship, or ideas and feelings worthy of respect and veneration. This is something that does not enter in the protection. And more than one object. So here in Brazil, although you have the flexibility to file up to 20 variations of a single object, it still must refer to one object. So you can file those variations provided that they are intended for the same purpose and share the same predominant distinctive characteristics. So it's very small changes for these variations, but they still have to refer to the same object. So the Brazilian law requires that each application brings a single inventive concept, but it allows those variations. So to have a industrial design here protected in Brazil, you need a unity of design. So you must have one design per application, up to 20 variations are allowed. All of them must have the same purpose requirement, and they can share and they need to share the distinctive feature. So those variations, as I mentioned, it's small variations, but that does not discharacterize the object. So you have this up to 20. It's not mandatory, of course. You can file less than that, but you need to refer to the same object and the same unit for the design. So what is required to file an industrial design in Brazil? Talking about the documents now. We will need a power of attorney, no need for notarization or legalization, only the simple copy. The full name and address of the applicant, the full name, address, nationality, and profession of the inventors or the designers that created the product, the drawings, at least 6 views of the drawings so we can have a good view of all the sides of the objects, the specification in Portuguese language in case it brings the specification, and in case it is claiming priority, we will need a certified copy of the priority translated into Portuguese. Also, does not need notarization or legalization. So basically, the documentation, it's quite simple. It's all of those informations, but it's really important to keep in mind that we will need the specification in Portuguese and also the certified copy of the application. Now in Brazil, it was stipulated by a new law that the power of attorney can be digitally signed, although we will need a certificate issued by a certification authority that are in accordance with this law. So you cannot just sign it and you can sign it digitally, but you have to prove that it was validated. So the digital signed power of attorney must be provided in a way that allows the verification of this digital signature. So some cases, just a digital signature without this validation, which we cannot access the certificate, will not be considered. So sometimes it's better to have it hand signed and send a copy for us. But there is a possibility to have it digitally signed once that we can find and check the validation of that signature. In this case, Brazil is quite bureaucratic regarding the digital signed power of attorney. So it's good to have in mind that, and even for Brazilian applicants, it's a bit easier because the certified authority, it's a Brazilian authority, so you can check it easily. For foreign applicants, it may be a little bit more difficult, so the hand signed one might be an option, but also it is possible to file with this digital signature. And if this power of attorney is not presented at the time of the filing, we can file it until 60 days after the filing. So we have this deadline to late file the power of attorney without any consequences. But if it's not filed within the 60 days, then you probably will have the definitive archiving of the application, because it's a mandatory document to start with the application in Brazil. So what are the views and representation of the industrial design here in Brazil? A little bit of a sum up. So we have a minimum requirement. So at least one figure must be sufficiently shown all the claimed design. But we always suggest to bring at least 6 orthogonal views in 3D. So we can have an entire overview of the object, and then we cannot have like office action for lack of clarity or things like that. Any omitted identical view must be expressly declared in the description. This is quite important as well. Solid lines define all the claims. Dashed lines indicate contextual and unclaimed elements. So everything that is in dashed lines will not be considered claimed for the industrial design. And the consistency of the object. So dashed lines, hashing, or shading must be clearly explained in the description, because they can bring confusion to the examiner. So must be very, very aware that all the solid lines are what will be claimed for the industrial design. Anything that is different from that must be explained in the description and bring the information very clear for the examiner. And something that may happen in industrial designs is the division of applications, but only in a very specific way. You can only have a division of an application after a office action from the Brazilian PTO requesting you to do so. So it is exclusively from following a technical objection from the Brazilian PTO. They will issue this office action requesting you to divide the application and telling why and what it would be best to do so. Of course, that to have this division, the original one must exist. So the parent application must remain active and pending for the division to be valid. You cannot just exclude one of them and keep the other. You have a 60 days deadline to respond to this office action, filing the divisional. So having this divisional for it to be considered, to be allowed. And the deadlines, the missing this deadline of 60 days may result in the divisional being non-existent, and maybe even the refusal of the original one. So you must be very aware of that. It is possible to have a division application in Brazil, but only after the Brazilian PTO, the examiner, express this need and that this is needed to file in the industrial design. You cannot do it voluntarily. So the division, it's a remedy, not a right. It can't be proactively used to cure strategic filing errors or bypass unit requirements. So you cannot try to file this division to change something in the original one. It is something that will be required from the examiner and then must be done in order to have it granted, not to have any problem with the application. And the priority document, which is something that is quite important in Brazil, pay attention to all those details that I'll mention following. So to preserve this priority rights, the applicant must submit the complete documentation for the Brazilian PTO formal requirements. And what are the informations that the Brazilian PTO look into the priority documents? Anything that is outside of the information that I will tell you about can't be included until 60 days deadline. This is kind of a managing deadline that we have. But after that, it's not possible to send any missing documentation or any missing information. And then you will lose the priority. The Brazilian PTO will not accept anything outside of this deadline. So in the priority, what they will look for the information, they will look for the country or office of origin. So you must have a clear identification of the jurisdiction where the priority was filed. You have the application details, so the number and the exact filing date of the application must be shown in the priority document. Of course, the visual representation, so figures, drawings, or photographs showing the design disclosed in the priority filing. Also, all these key data must be translated into Portuguese or must bring a formal declaration made by the Brazilian representative confirming that all data on the priority are true and are valid and have it in Portuguese as well. If the priority it's with a different applicant from the Brazilian application, then you must bring an assignment document too. You cannot have the priority on behalf of one applicant and the Brazilian application on behalf of other applicant. You must show the assignment document or anything that shows that all the rights was passed to this other applicant so they can have this right to file in Brazil. All of this supporting documentation may be included in official copies or some reproductions of publications, but also the Brazilian PTO accepts the DES code from WIPO, so they can have access to the official documents in the digital priority. So you can either send the certified copy or the DES code to have access to those informations. And now I pass on to Rafael to continue that.
Sure, thank you, Juliana. Basically, we were talking now about something new on the guidelines, the laws of priority. So we have some practical triggers here in Brazil to avoid the laws of priority. So first, if the priority has no correspondence, for instance, the priority document show a different design for what was claimed in the filing, basically, we will have the loss of priority in the country. Also, if we have an incomplete priority document, missing figures or filing number or filing date, this is crucial. So Brazilian PTO can check if the priority details are matching with what is claimed in the country. If the representation mismatch, for instance, drawings or color, shading difference, priority accepted if no change in the claim design. Priority lost if the differences alter the scope of the claim. So for instance, if you file the case and you have the latest filing of the priority, if that priority does not match the initial design claimed, you probably has the loss of priority. Basically, they will check if the priority, they have some differences with the scope claimed. There is no post-adjustment, just post-filing adjustments. The Brazilian application cannot be amended to match the priority document. It's now crystal clear in the design guidelines. And appeal is available. If you lose the priority, so if you have a loss of the priority rights, you can appeal against the decision within 60 days from the publication, the notice of loss of priority in the official gazette, the Brazilian official gazette. A practical tip is when you have a design to be filed in Brazil claiming priority, use identical drawings. So even though we have some objection and adjustment to be made, you will keep the priority rights. And unlike some jurisdictions, Brazil offers no post-deadline remedies. So compliance is mandatory and strict so important in Brazil. Basically, this is a huge difference of the past manual because this is now clear and well explained in the guidelines, the new ones published last month. As you probably know, Brazil is a country member of Hague Convention for designs. And we have several differences, we could say reservations against Hague Convention. So now we will understand the Brazilian PTO approach in terms of unit requirements for the international design. So for instance, the refusal assessment. Hague allows up to 100 designs per applications. This is not possible in Brazil because Brazil requires only one design, as Juliana mentioned, up to 20 variations of the same design, of course, if they keep same purpose and distinctive feature. Same Locarno class alone is not sufficient in Brazil. In Hague, it's okay. We have same Locarno. You can, for instance, claim same Locarno and use different designs. In Brazil, no, just one design, one chair, one table. Not because it's in the same Locarno, you can use and file the design in the country. That's a huge difference. Also, the design selection, the divisional. When the unit is challenged by the examiner, the applicant must select one design for the application to proceed with the examination, and the remaining designs can be filed as separate national divisions. Of course, as we mentioned before, the division cannot be something voluntary. It should be requested by the examiner. Of course, you can preserve the original international filing date, the priority date, if it matches with the claimed design. But when you do the division, you can, of course, keep the priority rights. And the priority, Brazil accepts the desk code. However, if the desk code is not informed at the moment of the international filing, it's possible to file the desk code or the certified copy of the priority within 90 days from the publication, okay? However, a local representative before the Brazilian PTO should be hired. You cannot simply file before WIPO, the international secretary. You should hire a local counsel to file the priority. You can use test or you can use certified document, but a local counsel is required and the deadline is 90 days. There is a huge difference of 90 days and 3 months. Yesterday, I handled a case like that. It's different. 90 days is different of 3 months. Our lines bring some differences between months and days. So in this case, 90 days, okay? And the merge covered by a rule of the common regulation of Hague does not apply in Brazil. The Hague filings, they require Brazilian specific planning because we have particularities. So the unit is the number one you should pay attention to avoid extra costs and expensive fees for reply to obstructions, and also the priority. You should be attentive because otherwise we will lose the priority right. Now, talking more about the flow of the designs in Brazil, how that works. Basically, there is no substantial examination procedure in Brazil. So what we have when the design is applied and filed in the country is a formal examination. Brazilian PTO will review documents, fees, power of attorney, for instance, if the design representations are accordingly, basically, if any defect exists, but minimum is met, okay? Otherwise, a formal requirement and a formal off-section will be issued. The applicant should be attentive because you have only 5 days to respond to the off-section. If you fail to respond this, the application will be considered as non-existent in the country. Basically, the formal examination is related to relative grounds only. What is reviewed? What is analyzed? So the design qualifies for protection under Brazilian law. For instance, it is a function-driven form or architectural project, or the design is contrary to morals or good customs in Brazil. This is what the examination, the formal examination is also after the formal examination, the relative grounds is analyzed. So we have a second phase here, but this second phase is only relative ground, only matching our law. After that, the design is granted in the country. So basically, if you have a design in Brazil, it will pass for formal examination and examination of relative grounds, no substantive examination. After the grant, if you'd like to request the substantive examination, it's possible to, okay? Consider the grant is automatically. This is a, I would say, crucial requirement to use in the lawsuits against others. Basically, if you have a lawsuit in Brazil, the main argument will be, oh, judge, the designs in Brazil are granted automatic. So what we need to do is, before we consider a lawsuit in Brazil, let's ask the substantive examination. So the design will be having more enforcement in the country. This is optional, and this has extra fees in the country. So Brazilian PTO will analyze when we request the substantive examination after the grant, the pre-existing designs. It will evaluate the novelty and originality of the design, okay? So, of course, this is if you would like to enforce your right in Brazil. And the time frame of analysis of the designs in Brazil nowadays are around 6 to 8 months. Each design is analyzed, of course, as I told you. The examination is made according to our law, but not substantive examination. Around 6 to 8 months to mature into registration. If you have some extraordinary situation, for instance, off-sections or rejection or any unexpected fact, we will have extra time, for instance, 12 months, 14 months. And what people ask me is, when the certificate is issued, basically, I will explain the next slides that we have 60 days to file a cancellation against the design. Brazilian PTO usually awaits this time. So usually the certificate is issued in more than 2 months, 3 months from the date of grant. That's after the grant, you have around 3 months to receive the certificate, okay? Something really important, change of name, or change the address, transfer the assignment. When you do this, you need to understand that a new certificate can be requested, but under extra fees. So in case of any document in foreign language, simple translation is required for the change of name. And you needed to show that the company changed the address change the name, but with a document bringing these two data, name and address. If you show a document only bringing an address without the name of the company, Brazilian PTO cannot check if we are talking about the same company, the same applicant we are trying to change. So one unique document, you can for instance, file the articles of incorporation, the licensing, the business licensing. So you can file a statement, you can sign a statement with the new address, anything that brings this two data, name and address of the firm, okay? And in terms of the assignment, we needed to follow some paths of the PTO. Some people ask us to file assignment, the deed of assignment made abroad. Basically, we analyze if it matches the requirements of the Brazilian PTO. If matches, it's okay. We simply translate this into Brazilian language, and it's simple translation, okay? And no legalization is required, no notarization is required. It's simple. However, we needed to put this in Portuguese language. And of course, we need not only the assignment document, but also the power of attorney in the name of the assignee, in the name of the company or individual that receives the right, receives the design. Okay, so something in the past that we couldn't, and now we can. And I have a very remarkable case that the design was refused, or actually an objection was raised because it included logo. And after the guidelines changed and we could keep the trademark, okay? Now trademarks can be included in the designs. However, no trademarks is granted, okay? But applicant can bear the full responsibility for the trademark included in the design. And now trademarks can be included in the designs in Brazil. Copyright as well. Of course, test images, authorization for the marks and the copyrights and the images of individuals, any logos, etc. They recommend to show an authorization. It's important because it avoids off sections. So, of course, if you have, for instance, typeface familiarities, also human form, you need to basically ask the authorization and attach with your design, but it's now possible in Brazil. And as I told you about the digital certificate, basically it takes around 2 up to 3 months to have from the notice of grant for being issued. The design is in the certificate in Brazil. This is digital format only. Okay, no paper certificates are issued in Brazil. This is automatic. So as we have the notice of grant, we have automatic certificate generated in Brazil. There is no additional fee. As soon as we have the notice of grant, we have the certificate issued. But the changes made after the grant, such as change of ownership, the ownership transfer, the assignments, or change of name or address, they are not reflected in the original certificate. So a new updated certificate must be required if you would like to, okay? And extra fees are applied. A new certificate is really issued by the Brazilian PTO with the updated data. Now, something really important is the validity and the maintenance fees in Brazil. Something really good in these guidelines, this recent updates of 2026, is that now the guidelines consolidates the existing law, and now everything is clear in the guideline. These requirements, they are not nil, but they are clearly defined in these new guidelines. So basically, a design in Brazil can be valid for 25 years, okay? Of course, under legal condition. When you file the design, you have to pay in the year 5 a second quinquennial payment. So 1 year before the design completes 5 years, you are able to pay. That's the open window, and the deadline is 5 years after the filing. Okay, you pay this between the year 4 and the year 5 from the filing date. That's the first maintenance fees, the first quinquennial that should be paid. If you do not pay this one, the design will be extinguished. After more 5 years, between years 9 and 10, renewal payment is required. So you pay these renewal fees between year 9 and 10 from the filing date. After that, another renewal between years 14 and 15. So this open window is 1 year before the design achieves 15 years, and it's required for the continued protection. Another one between years 19 and 20, and the maximum protection, the term will expire in the year of 25, counting from the filing date. So that's the maximum validation in Brazil. Important, there is no restoration, no revival available in Brazil. You have a 6-month deadline period for the second quinquennial or for the renewals under extra fees. But if you miss this grace period, that will result the definitive extinction of the design in Brazil with no mechanism for revival, okay? And now something interesting, the post-grant cancellation or nullity. We have in Brazil something really interesting, that is the administrative nullity and, of course, the judicial nullity. And there is a huge difference of the administrative and judicial. The industrial design in Brazil can be cancelled, can be attacked, can be challenged within 5 years from the notice of grant before the PTO. Okay? Before the PTO. After these 5 years, you can use the judicial system. You can file a lawsuit against this design before the federal courts in Brazil. So before the PTO, which is cheaper, you have 5 years. However, if you file the cancellation within 60 days from the date of grant, the effects of the design registration, they will be automatically suspended. So basically, if you file the cancellation up 60 days after the notice of grant, the certificate, the notice of the grant will be automatically suspended. It's like the design return as an application and no more registration, but only if you file the cancellation up to 60 days from the grant. If you file the cancellation, the nullity, 61 days up to 5 years, you will, of course, receive the analysis of the PTO. They will check this, but the design remain in force. The design will keep the validation as a registration. Before that, they return as an application in Brazil. This is very interesting. And like patents in Brazil, because the law brings first patents, then designs, then trademarks, the Brazilian IP law. And the Brazilian IP law for designs, they follow some regulations of patents. And like patents in Brazil, the nullity action can be filed before the federal courts during the patent's terms and also during the design terms of cars. So the Brazilian PTO or any party with legitimate interest can file a challenge before the federal courts. There is no need to file first the cancellation before the PTO and after going court. No, you can go directly. But of course, if you file before the PTO, it's faster and it is cheaper. Okay. We are finishing our webinar. So some takeaways for you guys. So Manuel, the guidelines, they nowadays clarifies the practice. So 2026 Brazilian PTO, the INPI, the National Institute of Industrial Property, consolidates, clarifies the existing law. Okay. Now the priority is the highest thing, the highest risk, because now it's crystal clear that should correspond to the initial design claimed. Hague requirements in Brazil are different. We have particularities, so we have a local specific things in the country. And the maintenance of Brazil is crucial to keep the design in force. So 5 years until 25 if you'd like to. Thank you so much for the attendance. We have here my QR code for WeChat and also WhatsApp of course, Juliana's contact as well for WhatsApp. And now we are opening we are open the webinar for questions. So if you have questions, you can put in the chat or you can press the button of questions. Okay, Juliana, we received a question about what is not protected in Brazil as a design. So I will return here. What is not protected in Brazil? Can you explain that, please?
Sure. I think one slide back, please, to bring it all together. So as we mentioned, anything that does not have the unit of design, the industrial design in Brazil need this unit, this sensation of unit, and some things that are purely artistic or purely geometrical without a function only and without a characteristic of ornamental of aesthetic characteristic cannot be registered, and also something that is just function you cannot. So you can't have just something that is just the aesthetic and just the functions. You must bring both of these parts together to be considered industrial design. So we bring the examples of some sculptures or something that is purely creative, basic geometric forms, or some shapes that are just for technical function without an ornamental part. Architecture projects, as we mentioned, may have some exceptions, but most of the times are not considered. Everything that is against the moral and the good costumes here in Brazil as well, offensive or to glorifying crimes and things like that. And also to have a industrial design, it is the unit of design. You can have those variations that the Brazilian PTO brings, this flexibility, also the ornamental and aesthetic part, and the function. So it must be a combination of all of that to have a industrial design here. Something that it's merely artistic, geometric, or just function cannot be registered here.
Thank you, Juliana. And we received 3 more questions. So, how can we distinguish variants in one design application? High similar. So basically, guys, if you have design in Brazil, and we are talking now about unit of design. If you have a design in Brazil, you need to see, first of all, if it's the same object. This is the beginning, okay? So for instance, let's think of a chair, okay? So a chair, if changes, basically small differences in the chair, but it's still a chair. It's still for the same purpose of sitting, okay? If share the distinct feature, for instance, you change some differences in the ornamental, but it's keeping as a chair, okay? You can consider as a variation, okay? Up to 20 variation is permitted. What is not permitted in Brazil, if you have, for instance, a chair and a table, this is different. This is not one design. This is 2 designs for Brazil. Although they can stay in the same Locarno, they are not considered as the same design in Brazil. So you needed to file separately. So this is one design, the chair. If the chair is high similar, yes, high similar. Because if you change totally the kind of the chair, for instance, one has a kind of back and the other has no back, and they don't keep any preponderant distinction. You change totally the format of the chair. You put something different that you cannot recognize as the same chair. Will be considered another design. Okay. Juliana would like to add something.
No, it's just, for example, keeping the chair, if you have the same back of the chair in both cases, but you change something about the part where you sit, then it might be considered because you see it's the same chair, but a small variation. So they keep the main ornamental, the main function, but they change some details. One is rounded in the seating, another one is more like a square. They may be considered the same unit, the same object within the variations. So I would say that are small, subtle changes. You cannot change everything, as you mentioned, taking off the back of the chair, but it is considered. So if you have any doubts, of course, you can send to me and Rafael. We take a look before finding or something and give our opinion about it and explain why it might be considered different objects or might be considered the same design.
Of course. Another question is, if we provide this code, should we still need to provide translation? So let's separate this question in 2. If you provide this code when you are filing the design before a Hague Convention, it's not required you provide any translation. You just simply show the desk code. But when you file in Brazil, it's better you provide the desk code and any reference to the cover page of the design. Basically, the data of the applicant, the inventor, we can make a simple declaration. So not a translation is required. No, you can simply put the desk, but it's good to also show the data of the priority with a declaration or explaining to the Brazilian PTO in the petition the data of the priority that you are claiming and inform the DES. Okay, that's simple. However, if you file after the international registration, you needed to hire a local counsel, okay? Because you cannot simply file before the international secretary or before the PTO. You need a Brazilian counsel, Brazilian attorney, Brazilian representative to act on the applicant's behalf because of our law in the Article 217. So it's basically required that the local council act in Brazil after you need to do something before the PTO. Juliana, I would like to complement something.
No, that's perfect.
And about the 180 days of the confidentiality, okay? Guys, this is really simple, okay? What happened is, let me think. Let me show you the exactly here. When you would like to hide, okay, the data in Brazil, you can request the confidentiality. They will not publish your design up to 180 days. Okay. You need to ask this when you file the application. When you, for instance, entrust us a case, you ask us, please mark this design as confidential for 180 days because it's made in the filing request to the Brazilian PTO. So we simply click in the form to the Brazilian PTO that would like to keep this as confidential. What we put here that is important is up to 90 days, you can take off the registration. You can withdraw the registration from 90 days of the filing date, and the design will be not published at all. But after that, you can basically you can after this 90 days, you can basically not withdraw the case because it will be published. It will be shown in the PTO website, and it will be published with all the data. Another question here: we will postpone the formality examiner if you request the confidentiality. Basically, yes, because we needed to await the design be notified in our magazine to be analyzed. No objection can be made. But if we have some cases in practices that objection is made, but people do not know anything about the design. So they have no information about the case. Basically is, oh, the objection is made for the design and show the number, and they explain the objection but not mention any detail. It will postpone basically the time of analysis, because not the formal one, but the analysis that is the second examination with no formal examination. Let me show you. Go ahead, Juliana, sorry.
No, that was what I was going to say. I wouldn't say the formal examination, that is regarding the documents, but the relative grounds may be delayed a little bit because of the confidentiality.
Yes, this one. So we have the formal examination. This is probably something that they will issue an objection. You need to reply with 5 days. There is no problem. But this one will be delayed. The relative grounds, if, for instance, is function driving or architectural project, contrary to morals, this will not be made until the design is published.
Yeah, the main strategic reasons for the confidentiality is to keep the filing date without having the disclosure of the design. So yeah, this is what must take into consideration.
Okay, no, thank you guys. I really thank you all for your kind attention and your attendance again. If you'd like to receive this material, please contact us via email or WeChat, and we will send it to you. And it's also a pleasure to really be in touch and explain these interesting matters about the updates of 2026 guidelines of design in Brazil. Thank you so much.
Thank you. And any questions, you can reach out to us later as well through email or WeChat or anything that's better for you.
Thank you. Have a wonderful evening. Bye-bye.
Bye.